reasons not to harm your loved ones during quarantine. Today, we are going to talk about what a trial is, the anatomy of trial, and give some information. Oh, my computer's doing funky things. I think I should start over. Okay. This is episode 26, take 2, of 5 reasons not to harm your loved ones during quarantine. Today's topics are going to include anatomy of a trial, what is a trial, the difference between a civil and criminal trial, and if anyone was wondering where these topics come from, I always believe, and hello, welcome back. I lost my internet connection, so I apologize, but we will continue with episode 26 of 5 reasons not to harm your family during quarantine. And I hope that those of you who just tuned in will go back and listen to part 1, where we were going through some important updates. I am outside, even though it's raining. It just is such fresh air, and I don't know, it smells like spring, and there's just something happy about being outside in the rain, especially when you can be protected. But the last thing that I had said before we got cut off was that when we're looking at the number of deaths, which are up 160 from yesterday, and the number of cases confirmed, which are up 3,407 from yesterday, remember that we have more testing now. We have efforts in nursing homes. We have efforts in all different sectors, drive-through testing all over the state. So, and we also, with the more freedom to travel within the state, you're going to see more cases up north where they didn't have any before. So it's going to be a very different dynamic than what we're used to when we're looking at these numbers, and I wouldn't be surprised if we just know about more of them in the coming weeks. And so, question for all of you. I'm going to make you actually participate today. So in your little box where you can chat, I want to know who agrees and who disagrees with what I'm about to tell you about the jails and what's going on. So as we've talked about, jails are kind of a breeding ground for any disease, not just COVID-19, but especially COVID-19, because we don't know what it really looks like when it's shedding and when people can actually get it. So as of now, there have been 41 confirmed cases in the Oakland County Jail. There have been 5 confirmed cases in the Macomb County Jail, and 26 confirmed cases in the Wayne County Jail. Those are inmate numbers. It is not known how many inmates, either that have COVID-19 or that are just in jail or incarcerated, have pre-existing conditions, asthma or COPD. It is not known what the age is of these people. And it's also not known how many employees, and we're not just talking about sheriff's deputies, we're talking about medical people who come in there, there's teachers that come in there, there's probation officers that come in there, there's attorneys that come in there. And so we don't have those numbers either. But prior to the last couple weeks, they were doing no testing in the Wayne County Jail. And, oh, I forgot this little issue with jails. There's constantly inmates coming in and out. You know, they're in at the end of their sentence, if it was a sentence less than a year, or they're waiting trial or waiting sentencing or waiting pretrial, and they don't have a bond that they can reach or they can pay to get out, or they don't have a bond at all. And so those are some of the issues. So my big question, and I hope that all of a sudden my comment bar just goes through the roof, is do you think that it's appropriate for inmates, once they have COVID-19 confirmed, to be released either on tether or on home detention, or so that they can get proper medical care, not be spreading it to other inmates, and they can be properly quarantined. What do you think? I think it's a wonderful idea personally, but again, we're going to bring confirmed cases back out into the community and rely on them to stay home. So kind of interesting table talk, but I'm really interested in what you have to say. So please, write in the comment area and let me know what you think. The only other thing that I wanted to kind of survey about and see what you guys thought is the federal government, the Ministry of Home Affairs, who I didn't even know existed until this morning, they have issued an order that allows students, tourists, and migrant workers who have been stranded out of their home state to return to their home state. So, and the way that this is going to be put in place is they're going to be bused, and the buses will be sterilized, and there'll be social distancing, and then they will be in institutional quarantine. I'm not sure what that means upon arrival to their home state, and they will be tested before they're released. It wasn't clear from reading the order if they're tested before they even get on the bus. So that was kind of my question and why I thought I would throw it out there to all of you if we thought that this was a good idea. And do you think that it should be more specific on whether or not, depending on where they're coming from and where they're going? I mean, certainly if there's someone who's stranded in New York City, I'm not so sure I want them coming to my neighborhood right now. But, maybe it doesn't matter because they are screened and everything else. So those are my two big questions for all of you to chime in on, if you would. Next, actually, our anatomy of a trial. A couple different things. So not all cases go to trial, and actually most cases do not go to trial. Most cases, if they're criminal cases, there's a plea, which would be a guilty plea or a no contest plea. A no contest plea means that the court will find you guilty, but you don't have to admit what you did. Or civil cases, which are cases about money or about performance of a contract, or a divorce, for example, would be a civil case. Personal injury is a civil case. Corporate matters are civil cases unless they cross into criminal because they're fraud or embezzlement or something like that. White collar crimes, but for the most part, corporate issues are resolved in civil proceedings. Civil cases and criminal cases, as I said, most of them resolve, but the ones that don't go to trial. When a case goes to trial, it can be before a jury or before a bench, which means before the judge without a jury. In a criminal case, both the prosecutor who represents the people of the state of Michigan and the defendant each have their own right to a jury trial. So you have to agree if you both want a jury trial or if you both want a trial just before a judge without a jury. And also, if you don't, in all of these situations, criminal or civil, if you don't request a jury trial in the initial part of the case, or if you waive the jury and only request a judge trial at the beginning of the case, you lose it. You don't get it back, except under really specific, very specific guidelines. There was one case that we did have to file a motion and get it back in 26 years that I actually had to file that, and we did win. So that was good. But so that's something that, that happens very early on, and then you actually get to the trial. And The way that trials work is if it's a jury trial, there'll be, I don't know if any of you have ever been called for jury duty, but if you have, then you had to fill out your name and where you work, and if you have any children living at home, your marital status, where your spouse works, things like that. And then that's sent into the jury office, and then you get your summons and you come to jury duty. And then the attorneys for the case that's going to trial, we can view those the day before or 2 days before the trial. And in some courts, really, it's that morning, and see who's going to be in the jury pool. The jury pool, depending on the kind of case, could be anywhere from, in a misdemeanor, it might be 30 jurors, to a capital felony, a possible life penalty case, it could be 150 jurors. And then you go through a process called voir dire. Voir dire means to see the truth. And so what happens in that is that the jury pool will be asked certain questions that would disqualify them from being jurors or would show bias. One of those questions might be, have you ever been convicted of a felony? If you've been convicted of a felony in Michigan, you're disqualified from jury service forever. Another one might be if you're over the age of 70. In Michigan, if you're over the age of 70, you have the option of not serving as a juror. They may ask in those general questions to the whole pool if anyone has a medical issue or a hardship that would prevent them from serving on the jury for the anticipated amount of time of the trial. And those would be discretionary if the court would excuse those people. There's also people, if it's a criminal trial, they'll hear the charge. And let's say that it's a criminal sexual conduct case, which is sexual assault. There's going to be people in the jury that, no matter what, cannot be fair in that kind of case. It's just not the type of case that they can put their bias and their prejudice aside and objectively assume that the person accused is innocent. They shouldn't be jurors. They're too biased. And a lot of people are just too emotional from their own experiences to put their own experiences aside and really just focus on the trial. So those are sort of some of the preliminary questions. Other preliminary questions are whether you know the attorneys, the defendant, the judge's staff, and the witness list will be read, and whether or not you know any of the witnesses. So after all those questions are asked, then the attorneys in most courtrooms, because some judges don't allow this part to happen, we ask questions of the jury panel. The jury panel are the people who are randomly picked from the pool that then go sit in the jury box, like you see on TV. And then the attorneys can ask them questions. For example, one question might be, everyone knows that you have a right to remain silent. Well, what that means is that you don't have to testify in your trial, and that the burden of proof in the trial, if it's a criminal trial, and that's what I'm talking about right now, is that the jury cannot hold it against you as a defendant if you don't go sit in the witness stand and say I didn't do it. And also, because the prosecution has the burden of proof of beyond a reasonable doubt, the defense doesn't have to do anything. They don't have to call any witnesses. They don't have to present any evidence of their own, and that can't be held against them. So we ask questions of the panel to ensure that they understand and are comfortable making decisions and evaluating the facts and holding the prosecutor to their burden without two sides to the story, without someone saying, I didn't do it. And A lot of people really can't do that because it's counterintuitive to the way that we live our everyday lives. So voir dire is a really interesting process. And it's also, I mean, I find it interesting when you talk about the presumption of innocence, because, you know, everybody looked at the newspaper that morning, and we live in Michigan. So more than likely there was, you know, some crime that occurred the day before. Um, you know, for example, there was a nurse from Windsor who got stopped at the border with, you know, many Ks of marijuana. And, you know, when you saw that, headline, how many people said, "Oh, I wonder what she's innocent of?" Or, if you happen to be going through the, you know, across the border at the same time as this nurse, and you saw her pulled over with her, you know, arms up on the car being searched, did you say to yourself, "I wonder what that innocent person did for them to stop her"? Well, this is how we're asking jurors to think. And it's very, very counterintuitive to the way we make our everyday decisions and our everyday fact finding. So that's the purpose of voir dire, is to identify people who can do that and be fair and not prejudicial and unbiased, and really be open-minded and hold the prosecutor to their burden. Jurors are, in some courts, are allowed to take notes. In some courts, they're not. In some courts, jurors are allowed to ask witnesses questions. In other courts, they're not. And so after the jury is picked, then they'll be given some instructions, and then it goes to opening statements. And the prosecutor goes first, then the defendant's opening statement if they choose to give one. And opening statements are really important. And the prosecutor usually uses it as a roadmap of what the proofs will be. And contrary, I think the defense philosophy is more like, I'm going to give you this structure, and this is where I want you to put the evidence. It's not a from A to B. It's, here's the structure, and stick this here, stick this here, stick this here, and you'll see that they haven't proven their case. And so opening statements are basically the preview to the movie, where each party says what the evidence is going to show. It's no opinions, it's no arguments, it's no spin. It's purely, this is what you're going to see. And the previews are different, usually. Then after opening statements, then the prosecution will begin to call their witnesses. That's called the case in chief. For every witness the prosecutor calls, the defense will be able to cross-examine that witness. And then if it's a courtroom that allows the jurors to ask questions, the jury will then be able to ask that witness questions. The way that jurors ask questions is they write them down on paper, they're given to the judge, the attorneys approach the bench and look at the question, and then it's decided if it's going to be answered or not. Some things that jurors ask are really interesting and really great questions, but it's not admissible evidence, so the answer will not be given. So then after the prosecution completes its case in chief, completes its witnesses, then it will be the time, if the defense is going to call witnesses or put on a case, then the defense would call their witnesses and the prosecutor would cross-examine the defense witnesses. After that happens, then you have closing arguments. And after closing arguments, the jurors will receive instructions on the law. And then the jurors who have been told from the very, very beginning that they cannot talk about the case with each other or anyone else, they cannot research the case, they cannot do anything but keep it inside themselves until after these instructions on the law. Then they will go into the jury room and they will begin to deliberate. The defendant is cloaked with the presumption of innocence. He is not guilty until the minute the jurors go in that room, evaluate the evidence, and if they do decide differently, decide differently. They can deliberate for as long as it takes. Some courts let it go for days. Some courts, don't. There can be hung juries, deadlock juries. There can be, they can ask for evidence to be for testimony to be reread. They can ask for the exhibits, if any were admitted, to be so that they can look at them, if there's photographs or fingerprints or a gun or the drugs, or they can look at and examine that evidence themselves and make their own conclusions on what weight, if any, it has. They can they'll be instructed as to how to judge witnesses, different things about to help them decide if they believe them or not. And when they're in that room all together collectively, they use their memory and make those determinations to reach a verdict. The possible verdicts in a criminal case are not guilty, guilty, or we can't decide, which wasn't really a verdict. That's an outcome. If the jury can't come to a decision, that's called a hung jury. That's a declaration by the court. And if the hung jury occurs and the judge declares a mistrial, then the defendant will be tried again. We will do the trial all over again another time with another jury. That's not the only way to have a mistrial granted, but that's a whole nother lecture for a whole nother day. And then if the defendant is found guilty, the next time that everyone returned to court would be for sentencing, and depending on the offense, that sentencing could be anywhere from probation and a fine to a jail sentence, a prison sentence, tether, boot camp, drug court. It could be any of the alternatives to incarceration that we've talked to on other live casts over the last few weeks. One really significant difference between a civil trial and a criminal trial that I just wanted to mention in closing here is that in a criminal trial, if someone takes the fifth, if they refuse to answer the questions because they might incriminate themselves, the jury is not allowed to infer anything negative. They're not allowed to infer anything at all, really, from someone not testifying or someone taking the fifth. In a civil trial, if someone takes the fifth, perhaps because they are risking criminal prosecution, then they would, then the jury can infer that if they had answered the question, it would hurt them. So there's a negative inference in a civil trial, and there's no inference in a criminal trial from a witness taking the fifth. So that was just one last thing that I wanted to touch on about the difference between civil and criminal trials. So with that, I wanted to just tell you we're going to be doing a series of Zoom meetings where you can tune in. We are going to have one with a child and adolescent psychologist talking about issues with our kids during these times with the lack of socialization, being home, not having their milestone events, graduation, spring break, whatever they may be. We are going to have some mental health experts talk about autism spectrum disorder, fetal alcohol syndrome, and PTSD, and how they impact criminal behavior and the ability or not to form criminal intent. We are going to have a judge talk about ways to have a more peaceful divorce or unknotting of your marital relationship. That will be another one. And then I don't know why I can't remember what the fourth one was right now. But so watch for those on our website. We're also going and on our Facebook page. And we are about to launch our library on our website. It's all kinds of, essays and pamphlets and checklists for different things, so that you can find out information yourself. Because, as I said before, having information is what helps us sleep at night and not having to worry and what if, woulda, shoulda, all that stuff. So with that reminder, 5 reasons not to harm your loved ones during quarantine. Protective services workers are essential. The police are essential. If kids are being kids, parents can get in trouble for that. The jails obviously are overcrowded and infected, and no one wants to go there. And 5th, very few people, if anyone, look good in horizontal stripes. So with that, I wish you all a wonderful, wonderful day, and I will see you tomorrow. Bye-bye. Hi, Nana.